I focus on design build because it's such a different beast when it comes to the insurance side of it. And, whereas before, back in the day, where it was a design bid build, if there was a design error, you catch it, you go back to the owner goes back to the design firm, and you do a change order to get that work done. And in our industry now, we kind of say that it's gone from being a change order to a claim, because now all that responsibility falls on the general contractor. So contractually, everything's changed a lot as far as the insurance piece of it is concerned. And so we focus a lot on the contract with the owner and the GC, but also the GC and the subs. And then you also have, a different subcontract agreement completely with your design firm. So, we look at every aspect of it, and there's a lot that has to go into it when we're looking at the risk transfer piece of it.
Great. How about you, Wes?
Well, I'd just say that when it comes to dealing with the owner on the legal side, the work that the legal team does always affects the surety, because when the jobs are bonded, surety bonds are actually very, very simple instruments. They basically guarantee performance of the entire contract. So that the work that the legal team does always has a backdoor effect on the liability of the job, both from the indemnity that is provided by the construction company, and in many cases, personally or individually by the company owners.
And I would add, you do need to make sure, and we deal with this probably routinely, is make sure there's enough coverage under your bond. It comes up, now you're seeing these mega projects like we were discussing, and there's a routine dialogue going back and forth is how much do we need to bond these projects for? And you would be surprised that the limits of these policies don't cover what you need. So.
Right, and that seems to be the case in insurance across the board, from the standpoint of, I have some property down in Florida, and, Hurricane Milton just did a number on the neighborhood, and we're all reassessing whether we're properly insured at this, we're puckered up and wiping our brow a little bit. So again, most of our audience is really interested in from the perspective of the contractor. So let's contrast that a little bit.
Sure. I can say the most important thing, at least from the initial perspective, is to read the contract and understand exactly what is in the terms of the contract. You would be surprised as well that how many folks, look, they get a good job, they see what they want to do, and look, this thing's got a lot of money, with the profit margins are there, but then there's some issues that are in the contract that they say, wow, I didn't realize that I was signing that. And that is a huge issue that we run into all the time. And from my perspective with the folks I deal with at Hogan, we spend an inordinate amount of time making sure that the terms and conditions of the contract are favorable to us so that we don't have to involve me. So on the front end, and that is really what we try to do, and I recommend that for everybody as well, is to read what's going on. It would save you a whole heck of a lot of time and expense to deal with me for 1 hour, 2 hours, to talking about what these terms mean, rather than try to wiggle out of an issue that is causing a major headache down the road.
So yeah, go ahead.
I was just going to say, correct me if I'm wrong, but that's an even bigger problem when it gets into the sub-trades, right? Where you have contracts that, instead of spelling out some of the most critical terms patently in the contract, they are draw down or pull down from the prime contract. And I think one of the bigger problems we see in the surety community is underwriters are asking questions that contractors can't answer about things like liquidated damages and dispute resolution clauses, because they refer back to a contract that in many cases the subcontractors themselves haven't even fully vetted.
Well, that was kind of my segue into the subcontractor part of this portion, as well as I think 99% of the subcontracts you deal with have the general contracts incorporated into the subcontract. And I would suspect that a large percentage of the subcontractors have never seen what the general contract says. So that's my first question to them is, well, do you have a copy of the general contract? What are the LDs that you're potentially subject to? Well, I have no idea. So you've got to ask these questions on the front end, and a lot of folks are concerned about interfering with business relationships, and these are my friends, and I don't want to ask these tough questions, but these aren't tough questions. They're questions that are, if you have such a good relationship with these folks, it's not a problem to ask it on the front end to get these documents, to make sure that you're properly protected when you're going into these projects.
George?
No, I agree 100%. And getting started early and getting all your consultants involved at early stage of the process. Understanding that insurance is not going to cover everything that you're exposed to on a contract. Insurance covers your legal liability and your financial liability in some cases. And so, understanding that what you're signing doesn't always translate into coverage or risk transfer on the back end of it. So understanding what you're signing, understanding what you can transfer to an insurance company, and also being comfortable with what you're retaining.
So I have a kind of a question for you guys that comes from the heart. If, all of us as individuals look at our estate and we think about a will and we meet with a lawyer and we know what's going on. We've read the contract and we've had a lawyer read that contract before we die, right? But a construction project oftentimes is larger than any one of our individual estates. I wish I could say I had $50 million to leave my kids, but I don't. But if I did, I would have a lawyer, I would have my legal representation read that in advance. To what extent do you find that contractors have you get engaged on the front end with a contract?
I would hope more than they do, but look, I think it is happening more and more recently. I think because people understand that you're spending a hell of a lot more money at the end of this thing when we're in a pickle than you're dealing with me to spend a few hours to review it. Now, I know nobody likes to see the bills, but that's the nature of the business. But it really protects you and safeguards your industry to look at everything just in terms of what's happening and what are your expectations about what's going to happen with this project. Not even exactly what the words in the contract say, but talking to the individuals in the industry, say what is your expectation as to how this project's going to play out, and does that relate to what's on this piece of paper? And that's really important.
So my old friend Paul Hogan comes into our classes and talks to our students, and you'd be happy to hear that one of the first things he tells them is read the contract. And when Paul says read the contract, is he saying that you individually should be reading the contract, or is he saying you need a professional to read this contract?
Well, Paul's a professional.
He is a professional. I'm not suggesting otherwise.
He can fly spec a contract better than most attorneys, and he is a, look, but there are questions that we have a very good relationship in terms of he knows exactly what to look for, and in terms of there are certain legal issues that we know to hone in on, but it depends on how extensive and long the contract is, But I certainly recommend that all the contractors in this industry read and review what they're signing, and if they have any questions, it's a simple phone call to call me up or call their attorney up and just ask what's going on, because those questions can be answered a lot quicker than dealing with issues later.
Right,
Yeah.
right. Great. Well, we're going to move along here, and obviously, the owner, the contractor, the subcontractor, the risks are similar, but what about the material supplier?
Well, I represent quite a few of those as well, and you'd be surprised that they don't know where the material's going half the time. So I would, we'd get projects and the representing material suppliers, it's not a difficult trade. It's where's the material going? Do we have perfected lien rights? Do we have rights against our subcontractor to make sure that we're perfected and it can get paid? And a lot of times the material supplier is not subject to a pay when paid clause, and the subcontractor is not really aware of that. So, and if they are, then they try to, look, the money will be here as soon as it is. But really it's where's the material going? Does our sales rep know where the material's going? And where's the project? Do we have sufficient information related to that project in order to perfect our rights to payment? And that's, it's a kind of a 1, 2, 3 step process that they can really work through.
So George, I'm going to throw this one your way, and we'll move our way across. what strategies are most effective in order to address risk at the inception of the project?
So when we're looking at a project and we're looking to assess the risk, we look at pretty much every aspect of the project. Is it commercial? Is it residential? Is it industrial? You know, what construction type is it? Is it, you know, frame? Is it CLT? Is it on the coast? Is it inland? So we're evaluating all the risks and associated with the project. We're talking through that with our customer. And going back to your previous question, I would say the majority of our customers send us the contract to review pretty early on in the process. So that allows us to do that. The other thing it allows us to do is that when we're looking at the contract and we're evaluating it for our customer, it gives us the opportunity to actually negotiate on behalf of them with the owner, with the GC, depending on who it is we're talking to maybe get some of that stuff out of the contract that doesn't necessarily apply to us. And so getting on early on in the process is vital to making sure that you have the right coverage in place, that you're not taking on more than what you're exposed to, and you know, having that dialogue back and forth with the owner. And that's pretty much how we handle it on the insurance side.
I mean, and certainly, I mean, think about it, and it's kind of what George was saying. I mean, a lot of folks in here, I'm sure, are regurgitating contracts that you've used on several different jobs. But for instance, I mean, you've got an issue regarding weather delays that was probably our pandemic-related delays that was in a contract that you're using that doesn't apply anymore. And then you've got these terms in there about, you know, how many weather impact-related delays that you have that should not be in there and that you really got to. So those are the issues that you need to look at from the inception of the project. Is a lot of stuff is not relevant and can be really trimmed down to make this more simplistic than some of these extensive contracts are.
Wes?
Well, as it relates to pre-con and negotiating these contracts, a surety bond very simply guarantees, the performance bond anyway, guarantees everything in the contract, incorporates it by reference. So the opportunity to get involved on the front end and partner particularly with legal and negotiate contract terms that are more favorable to the bond principal, which is the construction company, obviously has a great interest to the surety. We're probably, of any third party, probably have the most tied up in the construction contract outside of the contractor itself. So very beneficial to the surety.
Right, and like everything in construction, you know, the more energy you put in on the front end, the less you have to put in later on. There's a classic curve out there, and we all learned that in college. But the reality is once the contract is underway, once the project is underway, and we hear this all the time from our corporate partners, you know, we have to solve everybody's problems. You know, it's all, you know, the contract, everything comes down to the contractor once the contract has been signed. And from a legal standpoint, you know, do we give too much away during the project? Is the contractor really solving people's problems and paying money that they shouldn't be paying legally?
Well, not necessarily legally, but certainly you're not going to hurt anybody's feelings if the general contractor uses the contract as a tool in order to enforce its rights to get this project completed. You've got the right to put your subs on notice and to make sure that they supplement. And a lot of people are concerned about the relationships and whether they want to, you know, do that. But the general contractor's got to deal with the owner. And if this project's not on time, you've got to use your contractual rights during the project to make sure that this project's going to get up to speed and put your folks on notice. Because if you don't, then you're subjecting yourself, the general contractor, to having a litigation claim with your sub, even though then the GC is now subject to a potential LD claim from the owner. So you've got to make sure that you're using the contract as a tool in order to perfect your rights, and it's not going to hurt anybody's feelings if you use it in the way it's supposed to be used in order to get the project completed in a timely manner. You like that one?
I like that answer, but that's not what I'm hearing all the time.
No, you're not. But that's it's important. I mean, look, it's the way it works, and you've got to. And that's why I recommend to my clients: look, you've got to use it as it's drafted. I mean, why are the terms there if you're not going to use the contractual terms in the contract? So
right. And we heard earlier on, it comes right out of the profits of the project, right? I mean, that's basically your fees are paying, whenever you compromise and take a hit, it's coming right out of your fees.
Exactly.
Yeah. So does that affect your surety bond at all? I mean, do you guys grade on that or have any impression from it?
I mean, I think when there are more contractual disputes because parties aren't properly enforcing the terms, then yes, there's a sort of what we call underwriting friction that occurs in the industry where sureties start to back off. Is it done on an analytical basis? No. But over a period of time, a number of claims resulting from ineffective use of contractual terms absolutely build up and can reduce sureties' confidence in their client.
Right. Great. George, you got any thoughts on that?
I mean, not a ton, just because the insurance policy stands on its own. So it follows the contract in certain areas. But at the end of the day, there are triggers that they follow: bodily injury, property damage for general liability. You know, it could be a standard of care for professional liability. And so, you know, again, going back to what I said earlier is, you know, just because you sign it in the contract doesn't mean the insurance is going to follow you. So you have to be careful about that. So contractually, it's important because it passes on some stuff like additional insured status requirements and other things, but ultimately, it stands on its own.
Yeah, and nothing new here. I mean, what we're hearing is do your due diligence on the front end, make sure to read the contract, and if something goes wrong, be the adult in the room and try to help solve the problem. You know, I mean, that's kindergarten stuff, right? Some of us didn't listen, and it took us 40 years in the desert to get there, right? So I'm with you guys. Well, what mechanisms are available for all of us, owners, general contractors, subcontractors, material suppliers, to avoid risk on projects? So that's an important
Sure,
aspect,
that's a
avoiding
loaded one
risk.
there. So you've got, obviously, starting from the bottom up, you've got your material suppliers. They're limited. They've got their lien rights but theirs are, you know, you need to dialogue with your attorney about and make sure you are aware of your deadlines and rights, and don't have concern about sending those notices and making sure that you perfect your rights. The law gives you certain obligations and rights to use, and you should use them. Subcontractors as well, they need to understand the payment terms and exactly when and how they should get paid. I mean, we deal with it often. You submit an untimely payment application, that's your fault. You're not going to get paid on time. And you call up the general contractor and say, well, where's my money? Well, you knew when you were supposed to submit your payment. And I mean, and with your general contractor, it's making sure they understand, you know, the bond rights they've got, the payment performance bond, and how those interplay with the owner. And then the owner as well, they've got their liquidated damages in terms of how they can enforce and when this project is supposed to be delivered. So those are kind of your short way of interplaying all your issues.
Well, and thank you for that. There's something that's near and dear to everyone's mind now, and that's technology. So, you know, in the world we live in, cybersecurity, cyber risk is very real. So let's talk a little bit about what emerging risks actually are impacting insurance policies in construction today, and from a legal standpoint. You know, how are we responding to cyber attacks and that kind of thing that affect construction?
Well, in terms of payment, obviously it's a very, very big issue right now. And I mean, it's wire fraud and payment fraud I'm sure every email that you probably have sent between contractors and subcontractors and owners has verification of wire instructions and payment information. And it's a necessity these days, because if this is an emerging issue in the legal field, and if you're the party who has been spoofed, that's unfortunately, it's going to be your fault, and you might have to pay twice. And then what you deal with is you've got a substantial lien against your project, and you're dealing with an owner who's hopping mad and wants to get that lien off the project, and you got these folks involved, and they got to get a bond. And so it's a big issue, and all I can say is take your time, make sure you're understanding. Paul Hogan's policy is send a check in the mail, and I think it's a good one. I mean, it is you've got time to really understand what you're doing, and going the cautious route is not the bad route. And if a check gets there 2 days after your subcontractor wants it, and you've protected yourself, then so be it. So I think that's certainly a cautious way to take the approach.
So from a surety bond perspective, the method of payment, is that something you guys are looking into and talking about?
Well, I think it's more about the transfer of risk, because it seems these days that cyber crime and the effect on the construction community can't really be effectively managed at the individual level. I mean, that's a great policy, and we certainly hope that they're taking steps internally, but the most critical component from our standpoint to avoid payment bond claims because of the duplicate payment issue that Benjamin mentioned is that you're transferring that risk to a qualified cyber carrier, which of course George can talk about.
So yeah, I mean, we're seeing quite a bit, like Benjamin mentioned. You know, we've had probably 2 or 3 cases in the last 6 months where, you know, an invoice comes across your desk. It looks like it came from the proper sender. The email address is almost identical. It's missing maybe 1 digit or 1 letter, and all of a sudden you agree to pay it, and it goes into the abyss, and good luck getting it back, right? And so cyber is an evolving marketplace in general, just because it's such a new exposure that we see out in the marketplace. But and you get a lot of different coverages that carriers throw in. But at the end of the day, what people are buying primarily when they're buying a cyber policy is just you're buying the limit, you're buying the coverage, but you're also buying the backroom support from that carrier. The carrier that's going to help you make sure you get the notices out, make sure you're hitting all the legal requirements, and getting maybe the credit reporting and the credit monitoring that is required for folks. And so that's essential when you're looking at a cyber liability policy, is making sure that the carrier not only understands the cyber risk and the cyber exposure, but also has that backroom support to help you. A lot of them out there also have backroom IT support to help you if there's a ransomware attack or something like that, to actually get you back up online and getting you working again. So when you're looking at that, that's an important aspect when you're shopping your cyber liability policy.
So let's drill down on that a little bit, because there's some best practices. For example, I'm up here on my cell phone and I'm trying to multitask, and I'm gonna submit an invoice on my phone in a non-secure environment here. That's not good, you know. So let's talk a little bit about, you know, what steps should we be taking? And I know you guys aren't cyber police, but you've all taken the training. You've been through, you know, best practices.
So again, I'm not an IT specialist by any stretch of the imagination, even though my degree is in CIS, go figure. But having said that, you know, especially on your phone, get a VPN, right? Make sure that you have a VPN on your phone. You can get them for dirt cheap. You can get it through your IT program. Making sure that you're on a secure network. Try not to use public networks like at the airport or in hotels where someone can hack in. We've all heard the Target story when that claim occurred. And so those are just small things you can do, and try not to do transactions over electronic devices like Benjamin mentioned earlier, if you can avoid it, because unfortunately there's just no foolproof system out there that's going to prevent every single cyber attack.
Wes, you got any
I'll
thoughts?
just add that I've had numerous clients affected by cybercrime at various points over the last few years, and the one commonality that I hear from every one of them is that when that example happened, like what George was talking about, they call the police, they call the FBI, they call the IT experts, they make all these calls, and they get nothing. They get no help from anyone. The only party that actually has a vested interest in helping them and who has the expertise to help them are the claims folks from the cybercrime insurance specialists. Those are the only ones. Law enforcement is useless.
Right. Yeah, and you know, it's a very important thing. I mean, I watched a documentary on that Ashley Madison case the other night, actually, and you know, it's awful. I mean, I didn't know anything about that was going on, because of course I didn't have my name on Ashley Madison. But the yeah, I mean, it destroyed some people's lives. Yeah.
Well, and I would add, obviously, it's a good practices probably to review your policies with your counsel and see what coverage you've got out there, because I suspect it could happen to any of us, and you will run into a claim potentially, and making sure that you have coverage if in the event something like this happens is certainly very helpful. Yeah.
Well, that's a kind of an exciting topic to turn it over to you guys for questions. So do we have any questions of this panel? Got one in the back.
Hello, everyone. I'm actually interested in knowing if you have any experience or encountered any experiences with the legal implications for green buildings. Now, green buildings and sustainable buildings are being heavily advertised, and there's a lot of people saying that it's not meeting expectations. A lot of legal complications between whether the owner or the tenants are taking the architects and contractors to court. And we see a lot of these cases don't really go anywhere, just because of the simple fact there's no solid claim history in that area. But all of the implications of not meeting a certain certification, the losses of efficiency in these buildings, and all of these new topics that we are not used to deal with. How, if you actually encountered any of these experiences, can you reflect a little bit on those? And also, how can we avoid, as a professionals, not being dragged to court, basically, when it comes to that?
Well, I personally haven't dealt with any green buildings, but I mean, it's again, like we discussed from the beginning, it's what are the specifications of your contract? What are you asking whoever it is to build your project and in your facility? I mean, are they building it as per the specifications? And then so that's issue number one. I guess number two is, what do they require in terms of these green buildings? And I'm sure there's specific code requirements and that the building would need to, the standards it would need to provide and live up to. So those are the two issues that you would certainly need to look at the most. Obviously, regardless of whether it's green or not, I think there's requirements within at least South Carolina law, Georgia law, North Carolina law, or wherever, that would require how your building should be manufactured. Okay, so whether it's, and if it's LEED certified or something of that nature, but you've got, that's the issue that you certainly would need to investigate, and whether it would comply with that.
Thank you. Any other questions?
Hi, this is for Wes. Regarding your underwriting process, can you kind of explain any red flags or trends you've seen lately?
Well, that's an interesting question, because if you look back a couple of years ago, the industry was seeing an uptick in losses in the subcontractor space, and that is kind of a bellwether in our industry for bigger losses to come. They usually start in the subcontractor space and then gravitate from there. What's interesting and what's happened is that since then those losses haven't continued. So in 22 and 23 they were gradually upticking, and in the surety business, unlike insurance, we're a low frequency, high severity type business. So things go very, very well until they don't, and then they go very, very bad. So what the effect that has on our underwriting crews is that they will pull back very quickly as a result. And they did a little bit of that in 22 and 23, but looking through 3 quarters of 2024, the industry continues to be healthy, and losses are down. So there really aren't any yellow or red flags going on in the industry right now. There are certainly sectors that they're paying more close attention to, but nothing that's driving underwriting terms in a meaningful way.
There was another question over here. Yeah. You're getting your steps in today.
So earlier, we heard people talking about the different types of delivery methods and how the risk is changing over those. How does the coverages change based upon whether it's design bid build, and then design assist, and some of these longer lead design programs where they're going through a much larger pre-construction process lead into coverages and risk associated with that?
Sure. So, going back to my earlier comment, the main coverage that's impacted is probably the professional liability when it comes to design build versus design bid build. With the design bid build, obviously you're not contracting as the general contractor directly with the designer or the design firm. So, but on the design build project, now you actually are just, contracting directly with the design subcontractor. So there's a couple issues that go into that. First of all, carriers have actually limited their capacity with regards to the design build overall. They've seen a lot of losses in the marketplace, and so there's actually quite a few carriers that have pulled back. There's maybe 3 to 4 carriers that are really actively in the marketplace. In a lot of cases, if you don't have a practice program with them, they're not going to give you a standalone CPPI if for some reason you wanted to get a standalone policy. So what I would say is that a lot of the issues impacting that coverage specifically is the contract itself. So, when you're dealing with a design firm, a lot of times they have very low limits. All that limit applies to all their projects. And in a lot of cases nowadays, these design firms are pushing for limited liability clauses within the contract itself, right? And so in that, they want to limit it to their design fees. And so carriers are pushing back on that, and they're actually putting clauses in their policies now that are saying that you cannot agree to a limited liability in your contract without talking to us first. And so it's causing the prices to go up. It's causing them to underwrite the risk a lot more closely, especially on heavy street and road and large projects. And so that's the big impact that you're seeing with the project delivery method is on that line of coverage. And also when you're looking at projects in general, they're getting bigger and bigger and bigger. A lot of times people would use the 10% rule. So if it's a $100 million contract, you might get $10 million in professional liability. Well, if it's a $1 billion contract, you're not going to go out there and have the capacity to get $100 million in capacity, okay? So it's a big challenge. I think that progressive design build will help, hopefully. We'll see. We don't have enough data just yet to know for sure. But that's the real line of coverage that I believe is impacted the most.
Great. And, we have a wide range of folks in our audience here. Everything from the ambitious student that wants to go out there and hang up their shingle and go into business. And sorry, guys and gals, about the only bonding you're going to be able to come up with is the mortgage or the deed on your house if you don't have any history. So, you can't do a $20 million project unless you have a $20 million house. So that's where you start, right? And then on the other end, we have some very seasoned professionals in the room. So I'm going to ask the question that was presented here. How do you determine the appropriate levels of insurance coverage for different types of construction projects and for different types of subcontractors?
I guess that's me again. So going back to what I originally said a little while back is we look at construction type. Is it commercial? Is it residential? Is it industrial? Where is it located? Are you in a floodplain? Are you, on the coast? So we look at all of those, and it kind of goes back to the 10% rule that I talked about, which is a rule of thumb. You also, as far as your subs are concerned, I really advise most of my customers to come up with a matrix that is a minimum amount that you're going to require from your subs. You're not going to require the same limit from, say, a tile layer or for a roofer. It's going to be a little different, right? So having that base limit or limit that you're going to require of your subs, I think is vital. It's a starting point. You can always come back off of it. It's hard to go back afterward and get more. And so looking at that, and then you look at the different types of projects, right? And what the exposures look like. Residential is a great example. Residential is much more litigious than any other type of construction in most cases. You see that across the board. I worked in California for many years, and unfortunately that is a very highly litigious state. And so, even how you structure the policy with regards to, do you use a wrap-up? Do you have a project-specific policy? How do you structure the program to make sure that you're protecting yourself and all the interested parties? And so there's a lot that goes into it. I highly recommend that you get your consultant, your broker involved, and early on in the process to make sure that you're protecting yourself and the project and just walking through the exposures.
Great. Wes?
Well, the short answer in the surety world is that we don't. We don't set those limits. The contract owners do. By and large, every project that is bonded at 100% of the contract value, right? Both in a form of a performance bond and a separate payment bond for the same amount. Occasionally on some of the mega projects, we're seeing partial penalty bonds, but probably of greater concern for me is that in a good economy, when private sector developers are more aggressive, they forego the approximately 1% premium to get that performance guarantee on their projects. And so what you tend to see is at the very end of a healthy economy, whenever that happens, then you'll see a lot of defaults because those projects weren't bonded like they are required to be bonded in the public sector.
So Benjamin, do you encounter clients who are working on a project that's not bonded?
Certainly. I've got a project right now with the Georgia DOT where a general contractor forgot to obtain a payment bond. And the Georgia DOT is on the hook potentially for almost $900,000. So it happens more often than you think. And it's, in Georgia, the liability requirement is if it's $100,000 or more for a public project, you're required to obtain a bond, and if not, then the public entity's on the hook. Now, an owner, that's up to them. A private project, it's certainly up to the owner and the contractors as to how they want to deal with it. Back to what George was saying related to subcontractors and their liability and what we're seeing a lot lately as well is subcontractors trying to limit their liability to the amount of their contract dollar amount. And what general contractors need to be careful of is even if you're imposing a $1 million liability policy on your sub, they're trying to limit their liability as to the dollar amount of the contract. Say it's $500,000. That is certainly unenforceable in some jurisdictions, but you've got to be careful, and that's again why I strongly recommend you read the contract terms. But in terms of bonds, they're there. It's the private projects. We certainly recommend them most of the time, but it's really up to the owner and the general contractors how they want to deal with it.
So it brings up an interesting point. In a former life, I was a geotechnical engineer, and a structural engineer could do what I did. They were smarter than I was. So they were hiring me to get a $2 million insurance policy. So for $5,000, they would hire me and they'd get a $2 million insurance policy. It's good dollars on the investment. But once I figured that out, I was just like, come on, guys, is that really what this is all about? And I went on to become a college professor. So, but do you find subcontractors being hired for bonding purposes ever, or do you find games being played in the industry for bonding purposes?
You want to find subcontractors who are solvent and are able to pay their bills. Okay, yeah. You certainly doesn't necessarily know whether they've got AAA rating and are able to get a bond. It's more, what's the experience with this subcontractor and have I dealt with them before, and are they able to satisfy their requirements to material suppliers, because they're not going to get paid when the material supplier wants their money on an account within net 30 days. So they've got to be able to make sure that they can keep their legal obligations in check. And so it's not necessarily a bonding requirement, but it's certainly a solvency check. And we've had these discussions with, from several clients of mine recently is doing background checks on our trades to make sure that they are, they don't have any judgments against them. They don't have any, past issues. And that's becoming more and more prevalent in the industry as well, to see what's out there and related to any bad apples out there in the industry, because one bad job turns a whole series of jobs upside down.
Well, great. And this next question is is an advanced question. I'm just reading. So
Who put this one in?
so George, I'm going to throw this one to you. How do construction contracts and insurance policies align to protect project stakeholders from potential legal and financial liabilities, both downstream versus upstream risk?
That's a big question.
It's a big question.
Big question.
That's a master's level question, by the way, graduate students out there.
And before I begin, it's impressive that everybody's still paying attention and not asleep at this point in time in the presentation. But, you know, aligning the contract and the insurance is obviously a vital part of the project, right? It protects all the parties involved, from the general contractor, owner, subs, first, second tier subs, vendors, and it protects them against any legal and financial liabilities as a result. So, you know, when we're looking at a contract and we're reviewing it for our customer, we look at certain pockets of the contract to try to align the insurance with it. So we're looking at roles and responsibilities. What are you responsible for? Is it safety? You know, obviously it's schedule, it's a budget. And then, you know, I tell people all the time, I think I mentioned it earlier, is that your insurance policy is going to cover your legal liability. It's not going to necessarily cover everything that you sign in your contract. So, you know, if you have a delay that's a result of poor scheduling, that's a business risk, right? And versus, you know, someone gets hurt on your job, and now that's a liability risk that you can transfer to an insurance company on the general liability side. You know, contracts will also stipulate what insurance you're required to carry. A lot of times it'll say, hey, you know, builder's risk will be handled by the owner or maybe the GC, and then the subs will be required to cover, you know, their general liability, their equipment, their workers' compensation, professional liability in some cases. Now we're seeing cyber as a requirement in some of these contracts, as well as drone coverage, which is, you know, more and more common on these jobs. And so, you know, you read the contract, you try to align the policies as much as possible, protecting all parties involved. By doing that, you actually, you know, limit your exposure to disputes, and you also prevent long drawn-out battles, and you know, and hopefully minimizing the actual claim itself. And so it impacts all parties involved. It protects upstream and downstream as a result, and I think it's just an important part of your risk management process. And again, I go back to it again, you really need to get your legal counsel, your insurance broker, surety broker involved very early on in the process so that you can kind of get ahead of all those exposures.
Wes, what do you think?
I can't possibly improve on that.
Benjamin, you got any thoughts?
I think he did a fantastic job, and I don't know if I can reiterate the question that you said, but no, I think he did a great job.
So we're going to throw it back to the audience again and ask if there's any further questions. Anybody have any ideas or thoughts you want to share?
George, I got a question for you. A lot of our subcontractors now have delegated design responsibility. Talk to us about the insurance required for delegated design in our subcontracts.
Oh, delegating design?
Yeah, yeah.
So as far as just like with a design firm or with just all your subs?
How it relates to the general contractor when our subs are doing the design.
Oh, sure. So, you know, we see this a lot. There's a lot of contractors. First of all, a lot of contractors don't believe they have any exposure to design, right? Or, you know, professional liability in general. You see this with, you know, you do have contractors who, whether it's a mechanical contractor, who might do some work, you know, and they might fabricate some of the stuff and then install it. And what I would say is that, you know, we're seeing more and more push down from the GC down to the subs for professional liability. I tell this story about a claim that we had back in California when I was working there. It was a plumbing contractor. They did the work. And when the job was done, the pipe, every time someone flushed the toilet, the pipe would shimmy. and go like this, right? And as a result, eventually it gave way and it flooded out. And so, you know, we went to the GL carrier. The GL carrier said, no, it's a pollutant because it's dirty water, which I don't actually agree with, but that was their stance at the time.
That's called a water hammer in engineering, by the way.
The pollution had been placed after the project was completed, so the contractor decided to purchase that afterwards. Where we found coverage was on the professional liability side, right? And because they had to use the bracket to hold the pipe in place, and it should have had at least 2 to 3 to make sure it didn't shimmy back and forth. And so it's important that, you know, every contractor, in my opinion, has some exposure to professional liability. And whether it's your professional services or design. So we're seeing more and more of that being passed down.
Blame it on dirty water.
Dirty water.
I like that.
Dirty water.
Well, any other questions? Yes, sir.
For Wes, from a surety perspective. 2 questions. So first off, for P&P bond forms, do you have a form you like to write on AGC, AIA, custom form? And do you see advantage to that? And then the second question is, on private projects, when the owner's requiring bonding, how often are you able to convince the owner to bond the sub, to allow the GC to bond the subs as a dual obligee versus the GC being the bonded principal?
Sure. Well, on the question of the bond forms, I would say that the most common industry standard form is an AIA form, right? The 312, performance and payment bond. Is it the best? That's a very subjective question. It depends on which side of the table you're on. You know, as a broker who represents both general contractors and subcontractors, I find my side on both sides of that table from time to time. And I would tell you there are forms that are very favorable to the obligee on the bond, which for my general contractors, when negotiating or helping them draft, working with attorneys to helping them draft their custom form that they're going to push down as a requirement contractually to their subcontractors, that's better than the AIA. If I'm negotiating on behalf of my general contractor clients on the type of form they're going to provide upstream to their developers or public sector owners, then I want something that's very friendly, right? And there are friendlier forms even than the AIA. So it really more depends on the scenario and the parties that I'm representing. For public sector bonded projects, I would say it's fairly rare these days to waive, if I understand your question right.
I was saying, because procurement code is not going to allow you to waive on the public side. I was saying on the private side.
Understood. On the private side, I think it's fairly uncommon to get the owner to waive prime level bonds in lieu of bonds that run in favor of the owner from the subcontractors. And the reason is more in the underwriting world than anything else, because I was an underwriter for 16 years before I became a broker, and we don't want to write bonds in favor of parties that we don't have contractual privity with, right? So if you're even a first-tier sub, you really don't want to write a bond in favor of an owner because your contract's with a contractor. That's the person you're dealing with on a day-to-day basis, and so you really don't want to add parties. Typically, third-party dual obligees that you're talking about are limited to lenders and maybe some public authorities that have a vested interest in the project, and that's typically at the prime level. So certainly we want sub-bonds on projects, but it's usually by far more commonly done as an addition to prime bonds versus in lieu of prime bonds.
Great, great. Other questions? One in the back?
This one's for Benjamin.
Hold up, we'll get the microphone to you. 50 steps away from the 5,000 mark. We're getting good. We're almost there.
What are some of the most common terms and conditions when you're reviewing a contract for Hogan or any other general contractors that you represent that you most commonly strike or mark up or advise against, or, you know, in that regard?
Well, there's obviously you're dealing with a few. You've got your payment provisions that you've got to make sure of. Those are what are the terms the owner's going to pay vis-a-vis the Hogan and the subcontractors. You've got indemnity issues are a hot button issue, and what is my liability exposure? Scheduling issues. LDs is another issue that is obviously a very intense discussion. and anything related to delays. And those are probably, obviously, the definitions and the terms and conditions and what is incorporated into the contract as well. You've really got to read all of the defined definitions and to make sure that what the contractor is being required to do is actually an obligation that they have, okay? I mean, there are, who's responsible to get X permit? Is it the owner, is it a general contractor? And you would be surprised a lot of times that you see where there's an obligation that somebody didn't read what their responsibility was, and so it's not necessarily what we're striking, it's what you're reading and seeing whose obligation is what, okay? Because you don't want to require Hogan or you to do something that you knew that was not within your scope, and really make sure what's in your schedules. I mean, what is the scope of work defined in your Schedule A? And what are you seeing that is exactly, is this what I'm supposed to do and when? And then what is your subcontractor supposed to do and when? That's really what we kind of hone in on.
I got a follow-up. On average, how long does it take you to review a contract, and how many different iterations and back and forth does it take in order to kind of agree on,
Well, is it that's the cheap question or the expensive question? Where it's I mean, look, it takes an AIA contract, or we've dealt with those on a very often, okay? So they're specific, the general conditions are what you're really honing in on, so it shouldn't take more than a couple hours to review them. Obviously, it depends on your owner and how, what type of owner are you dealing with and whether they're reasonable or not, and what's the negotiation going to be like. So I'd say an estimated time, 3 to 4 hours at most. It shouldn't take much longer than that. If it does, then I don't know maybe the attorney's spending too much time. Not me, but somebody else. But no, it shouldn't take more than a couple hours, 3 to 4 hours.
We're going to hold you to that.
Oh. They review the bills, every single one of them.
Well, a couple of summary thoughts here for this panel, and thank you guys. George, Benjamin, Wes, you guys, fantastic. You guys have forgotten more about the legal implications of contracts than I'll ever know. And my takeaway is if I have legal needs, hire a professional, okay? And Paul, what's your advice to Paul Jr.? Read the contract. So yeah, two big takeaways. Read the contract and hire a professional. I tell my structures students, we're graduating construction science and management majors, and I tell my construction students, if you find yourself doing structural engineering, something's wrong. Hire a professional structural engineer. So we teach them how to do some things just to make them understand a little bit about what the structural engineer is doing and what looks right and what doesn't look right. But, again, hire a professional. So good job, guys. Thank you very much. So just a few quick comments, and I'm going to turn it over to Deval for some final remarks, but I just want to, and I don't want to steal any thunder from Deval, but this is our 9th annual symposium, the best one we've had yet. So thank you all for participating, and literally this has been a semester-long course in risk, in construction risk today, that we will build on and actually offer as a course in our curriculum at some point in the future. So Dr. Vivek Sharma will be delivering that course. He's around here somewhere. This is my 8th symposium that I've been involved with. And we all stand on the shoulders of others. So I'd like to just recognize that this symposium is the legacy of Roger Liska, our former chair, but no less the legacy of Bill Caldwell, who who helped Roger deliver the first annual symposium. So that was 9 years ago, amazingly. And I also want to recognize Bradley Robinson, who was on the panel, the last panel, because over the last few years, Bradley has been our corporate partner that has helped to deliver these symposia, and it just gets better every year. So this year, I want to recognize Paul Hogan as being our corporate partner representative that helped us deliver this symposium and strong-armed some of you guys to be here. So thank you, Paul. And that applause means that Paul's coming back next year, the 10th annual. He's not smiling, but he's happy about that. So I also want to recognize Leslie Armstrong. Leslie, thank you for all you do as our corporate partner program coordinator. And then a final special thanks to Dr. Deval Gajar for all you do. So with that, I'm formally getting out of the way and turning it over to Deval. Thanks, man. I'm putting on my invisibility hat again, so you guys won't see me escape.
Have you guys seen Mike? Well, thank you again. What a day. You guys enjoyed the day? All right, awesome. Thank you. Before, before we call it a day again, just a reminder again, thank you, Paul Hogan and Leslie, and, for all the corporate partners and our sponsors. We do have one more that we would like to acknowledge at the VIP level. That's Eldeco and Clary Hood. So if you're in the room, you're more than welcome to come up and say a few words if you'd like. Eldeco or Clary, you guys want to come up and say a few words, or? We're good. Love it. Thank you, guys. Last but not the least, I have told the bartender that we will not open the bar unless everyone takes this survey. So what you have to do is, pull out your phones and take this survey. It's really to evaluate, what you think about the symposium, how they go, and, like Mike said, every year it just keeps getting better and better and better. I've been fortunate to be part of Symposium. This is probably my 6th year in the Symposium, and my 3rd year probably, emceeing and, leading some of the sessions. I've thoroughly enjoyed every Symposium, and we'll be back next year again. It's going to be our 10th year, so you can expect something huge. It's been going on for almost a decade, which is a legacy to our previous professionals that have put this together, Roger Liska, like Mike said, and we're going to continue on that legacy. A couple other announcements as you take the survey. We do have our IAB meeting. It's an Industry Advisory Board meeting on February 13th, 2025. And 2025 is only about 10 weeks away, so we're almost there. So please note that date on your calendar. We would love to have you there. That's also our career fair where corporate partners get to come and get to hire some of the brightest from our program. And if you're not a corporate partner, and if you'd like to know what it takes to be one, please talk to Leslie, and she'll be more than happy to get that information to you. Along with that, I'd like to welcome Paul Hogan. Paul, please come on up on stage, as we do our closing remarks. And Paul, if you want to say a few words, because you work very hard on this, I know, and you're probably going to have an extra drink after this. So, do you want to share any closing remarks?
Sure. First of all, I want to thank each and every one of you for being here today, because each one of those seats that you're sitting in costs somebody some money. And the money that you paid today, and some of you I did strong arm. Didn't I, Benjamin? Some of you I did strong arm to make sure that we had good funding for the CSM department here at Clemson. I think the program is doing some outstanding things. I think this Excel yard is just outstanding. I think it's great that people are getting hands-on experience. I spent 12 years in the field before I finally got into the office. I guess I was just a slow learner. But the hands-on experience is exactly what you heard today that people are looking for. Ken Stockdale said it very eloquently. We need to know how to build and not count on the technology to build for us. Because if we don't know how to build, we don't know how to check the technology, do we? So it's imperative that you get out in the field. The young people that are here, that are going to Clemson, if you get a job and they send you to the field, hallelujah. because that's exactly where you need to be. You need to go out there and see things firsthand to see not only how to do things, but how long does it take to do things. Because I see people with schedules these days that bring them to my desk, and I look at them, I said, there's no way in God's green earth that these things are right. I said, it can't take you this long to do this. So the book of knowledge in construction is very voluminous. So for all the students that are here, you can never learn it all. I don't have to know everything in my company. I just have to know people that do know everything. And that way I can get things done. We talked about the business of business today. We talked about the business of risk management. We didn't talk anything about the nuts and bolts. I told you at the very beginning that was just entry into the dance. Just think about if we had tried to tie them together, we'd still be here next year this time. But to what the business of business is extremely important. I've seen more people go out of business because they didn't understand it than ever not knowing the nuts and bolts. And I will assure you, just because you're a good bulldozer operator doesn't make you an excavating contractor. As you heard from our last panel, there's a lot going on in those contracts. There's a lot going on in understanding liability and risk, and that's why I felt like it was so good to have this meeting today and help you understand the risks that we take on, because it is indeed the risk management business. So I thank you all for being here. That's all I got.
There's no more slides. You know what that means? Happy hour, rightly said. So again, this concludes our symposium. Thank you again, and thank you for sticking with us. We'll see you all in February, if not next year.